You want them brought down now?
I just need to have him sign it. If you want me to
Okay.
go down and go real quick.
Fine.
Right. Okay. Thanks, sir.
Going down the scene. 8547. Mr. Castleberry's on his way down to talk to his client.
All right, Mr. Hartung, what file are you here on?
Your Honor, I have a plea today with Sierra Gibson and Brian Fry.
He's back down to talk to him the second time.
Down. Mr. Amadeo, you are filing an appearance on Willis Baker. Is that correct, Mr. Amadeo?
That's correct, Your Honor.
All right. Is Willis Baker in the courtroom?
Yes.
Oh, you
He
want to
should
come
be
up?
there, Judge.
Yep, I got him. You want to come up to that podium? Thank you, ma'am. This is in the matter. Oh, hold on. This is in the matter of the people of the state of Michigan. Well, wrong Baker. Right Baker. There you go. That's the right Baker. Versus Willis Baker Jr., file number 22-20734FH. I have William Amadeo appearing on behalf of Mr. Baker. This is the date and time scheduled for request and summons for probation violation. So Mr. Baker, we are here today on the allegations that you have a non-technical probation violation, and that you violated condition 1 by violating a law of government in Hillsdale, where on November 21 of 2025 at approximately 11:20 p.m., it is alleged that you trespassed on 352 Village Green Boulevard in Hillsdale, Michigan. Previously having been trespassed from the property, complainant Kathleen Smith, who was the subject of an alleged assault on February 2nd of 24, and her mother, Eileen McNally, did not want him on the property. So do you understand those are the allegations against you? Speak up a little bit.
Yes, ma'am.
Okay. And Mr. Amadeo, you received a copy of this?
I did, Your Honor.
All right, let's see. Okay, so you are currently on probation for assault with a dangerous weapon, which carries a maximum penalty of up to 4 years in prison. Your guidelines were 2 to 17 months, and then a moving violation causing death. So you do have a right to counsel, and you've retained Mr. Amadeo. Are you satisfied with Mr. Amadeo as your attorney?
Yes, Your Honor.
Mr. Amadeo, how would you like to proceed today?
Your Honor, I'd like to adjourn this out. There's a misdemeanor in Hillsdale, as you said. I want to see what's happening with that case before we do anything. I don't want to hold a probation violation hearing in your court and take up your time. I want to track the case and see if I can come up with something global, or if I have to try that case, so be it. But I won't get into the details, Judge, but there is an explanation for what's going on, and I'd like to explore what's going on in Hillsdale before we make any decisions.
All right, and when is your next court date in Hillsdale?
Willis, when is the date? Because I didn't get that yet. What is the date on that?
The 20th of January.
January 20th?
Yes, ma'am.
All right, so Mr. Baker, I will, at the request of your attorney, adjourn this to January 28th at 8:30 in the morning. Mr. Baker, do not even drive down that street. Do you understand me?
I haven't, no.
Because if you do and you get caught, you're gonna go to jail
I understand.
and sit in jail until we resolve all this. You got it?
Yes, ma'am.
All right, so January
Has he-
28th.
Has he completed the domestic classes, the domestic violence classes?
All 52 of them, yes, I did. correct.
All 52 of them, he says?
For the
Make sure you
balance.
show that completion to your probation officer. Also,
She has-
your community service work.
I've done it, yes, ma'am.
You need to
Did
know
you,
that.
hold on, everybody, did you already provide that to the probation department?
Monahan and Hillsdale, yeah.
Okay, all right. Okay,
Yeah, I'm sorry, Agent Holly, to my knowledge, he's completed everything and handed it to Agent Monahan. I'll follow up with that, but I do believe she has the documentation.
Okay.
all right. Ms. Adams, could I get a notice of hearing from Mr. Baker for January 28th at 8:30 in the morning?
Yes, Judge.
All right, thank you.
Right.
Thank you, Your Honor. Have a good day.
Thank you so much.
Call me around noon. Mr. Goldstein, are you saying call you at 12? Or do you want me to call your case now?
No, Your Honor, that message was intended for Bill Amadeo.
Okay, all right. I mean, I would have called, but all right, Dustin King. Is there a Dustin King? Is there a Dustin King? Did you go get a Dustin King?
No.
Oh, okay, you got up. Let me see if he's, all right, I got a bunch of people in the waiting room. Let me see. I got a couple unmarked. So let me see.
Well, Mr. Packard brought in. 8547.
All right, I have somebody who has a screen that says Zoom user. I sent you a request to unmute your device. Could you please do so?
Yes, this is Claude Howard.
Claude Howard?
Yep.
Repeat that, please.
Claude Howard.
C-L-A-U-D-E and then H-O-W-A-R-D.
Yes, ma'am.
Okay, and who's your attorney?
James Daly. Mr. Daly.
All right, so I have changed your screen name and then I'm going to, wait, I think I changed the wrong one. Okay, so you have a beard, Mr.
Yeah.
Howard?
Yeah.
Oh, I changed the wrong screen name. I don't know whose name I changed, but I'll figure that out in just a minute. So, let me do that. Okay, so I changed your name. I'm gonna pop you in the waiting room. And when Mr. Daly gets here, I'll bring you back in. All right, so
Sounds good.
I changed someone's screen name. And I'm gonna send you a request to start video unless it's Claude Howard on both.
Yeah, that's mine.
Oh, okay. That was confusing. All right, I'm putting you in the waiting room too. All right, I have somebody on a, where'd it go? Oh, they hung up. Okay. Are you Dustin King? Dustin King? Do you want to call in the hall? It's not quite, well, it is 8:30. So Mr. Goldstein, I don't see him in my waiting room.
I just tried to call him and got no answer. I got voicemail.
All right, well, let me move over and do a plea and we'll see if he pops in, okay?
Judge, I've got to go to another court. I'll log back on in about an hour.
Not a problem. Thank you, Mr. Goldstein.
Your Honor, he's just calling me back. Hang on.
Okay. And after this one, I will take Mr. Shea and then Mr. Fry. So,
Thanks, Judge.
yeah, I just wanted you to know I see you there. I kind of go
You see
in
it.
order of who pops in. So,
You see a younger version of me there.
yeah, I do see that. It's okay. All right, okay. This is Mr. Packard. All right, can you stand at the podium? This is in the matter of people of the state of Michigan versus Cade Robert Packard. And does he have the advisory rights?
He does, Your Honor.
All right, and all right, so you are Cade Robert Packard.
Yes, ma'am.
All right, can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, in the matter of the people of the state of Michigan versus Cade Robert Packard, file number 25-22394FH. I have Bert Casberry appearing on behalf of the, Mr. Packard and Phoebe McClure appearing on behalf of the people. This is the date and time set for a pretrial in this matter. I have received a copy of a plea agreement, an amended felony information, and your client does have the advice of rights. So the plea agreement states that Mr. Packard will plead to count 2 attempted possession of a controlled substance, which carries a maximum penalty of up to 2 years in prison. He would be sentenced under 7411, any further incarceration to be suspended upon any non-technical violation. So I guess my question, Ms. McClure, is prosecutors don't get involved in violation of probations unless there's a trial. So if he gets a technical violation, you're trying to say I can't send him to jail for up to 14 days?
No, I'm not saying that at all. I'm just saying because the probation department's reached out and indicated that we word it like this now, because when we do no further upfront jail, they say that it limits them in what they can recommend upon any violation.
Okay, they didn't reach out to us, so I guess we weren't aware of that request, but I guess I will have a talk with them about that. All right. So
if I need to word it differently, I can certainly do that. That's just how I was told to do it.
No.
So.
And Mr. Castleberry, you understand that?
I think you're right.
Okay. And then count 1 would be dismissed. And is there no further incarceration as of today or as of sentencing?
Bond would be up to your honor's discretion.
Today. Okay. All right. So is that a correct recitation of the plea, Mr. Casper?
It is right.
All right. So Mr. Packard, you've heard, I read the plea agreement and you've heard the discussion between your attorney and the prosecutor. Is it your intention then to plead to the amended information and added count 2, attempted controlled substance possession of a mixture? What was it? Doesn't, would it still be the methamphetamine?
Your honor, it was a methamphetamine, but for purposes of the plea, we did reduce it to a general narcotics charge.
Okay. All right. So is it your intention to plead guilty to that?
Yes, Your Honor.
Do you understand if you're not successful on probation, you could be sentenced to prison up to 2 years?
Yes, Your Honor.
Okay. And do you understand 7411 means if you successfully complete probation, it won't show up on your record later on?
Yes, Your Honor.
All right. Are you satisfied with Mr. Castleberry as your attorney and the advice that he has given you?
Yes, Your Honor.
Other than the plea agreement, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Castleberry?
It is right.
Is that correct, Ms. McClure?
It is.
And Mr. Packard, is that correct as far as you're aware?
Yes, Your
All
Honor.
right. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have a right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, ma'am.
All right. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
Do you understand if your plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding, failing to appear for sentencing, violating terms of conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right, so how do you wish to plead to the charge that on or about August 7, did he already sign it? Okay,
Yes, ma'am.
thanks. How do you wish to plead to the charge that on or about August 7 of 2025 in Madison Township in the county of Lenawee that you did commit the offense, attempted controlled substances possession, less than 25 grams, guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Castleberry? Ms. McClure?
No, Your Honor.
Has your attorney promised you any other particular sentence or estimated what your sentence will be?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, ma'am.
Okay, so for purposes of the plea, on August 7th of 25, were you in Madison Township in the county of Lenawee?
What's that?
On August 7th of this year, were you in Madison Township in the county of Lenawee?
Yes, Your Honor.
Okay, and did you have in your possession, well, for purposes of the plea, did you have methamphetamine in your possession?
Yes, Your Honor.
Okay, you had no legal right to possess it?
No, Your Honor.
You understand you're not pleading to the methamphetamine charge, you're pleading to a lesser charge, and you had no medical prescription for it,
Yes, Your Honor.
and you knew it was methamphetamine.
Yes.
All right, are you satisfied, Ms. McClure?
I am, Your Honor.
Has court complied with MCR 6.302 B, C, and D, Mr. Castleberry and Ms. McClure?
It has.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the agreement. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Castleberry, are you available? Let's see what date she gave me. Are you available January 30th at 8:15?
Amen.
All right, would you like, so can we address bond first?
Yes.
Yeah,
Your Honor, I had a chance to speak with both the prosecutor and Mr. Coast this morning about Mr. Packard, and he's served over 20 days in jail on the violation. We are asking that he be released today, pending. Obviously, he's going to have to participate in the PSI. I have explained to him that if he violates bond, that this eliminates this deal, and that he will be put to jail and possibly sentenced to prison. So we're asking that he be released today, given an opportunity to show that he is going to stay clean, and we will be here for sentencing.
so Mr. Packard, where do you live?
Onstead.
Who do you live with?
My roommate, Andrew Chantos.
Does he have a criminal record?
I'm not aware.
Does he use any marijuana, anything like that?
Not that I'm aware of.
Is he employed?
Yes.
Okay, and okay, so methamphetamine is pretty addictive, right?
Yes.
Do you think going to a rehab might help you to start out with before you get released?
Inpatient or outpatient?
Either.
Outpatient would work because I'm trying to get right back to work and pay on my fines and restitutions as soon as possible.
What case do you have restitution on?
Well, I don't know if I have restitutions, but my fines.
I think you
my
mean
court
fines and
costs.
costs.
Okay,
Yes.
so what I will tell you right now, my biggest concern is making sure you don't get out and use.
Yes, ma'am.
I'm not worried about your fines, costs, restitution. You're gonna have 2 years to pay that off. But I'm asking you honestly, do you think you can get out and not use? Because if you use, this deal's out the window. You
I
understand? So if you feel like you need some help, we can set that up.
I feel like I can stay clean.
Okay, so Mr. Coast, I am, and Miss McClure, you said you were gonna leave that up to me, correct?
Yeah, Your Honor, I just want to make sure you were aware that the violation was for testing positive for cocaine, marijuana, and alcohol, and that this offense came about. There was another individual he was with that had a warrant, and he had the police contact that way. He was very cooperative with the police, and it does sound like he's done a significant amount of time on these violations, but I agree, he needs to keep it in line before sentencing.
All right, I'm going to give you a PR bond. Mr. Coast is going to monitor you when you're on bond. Mr. Coast, I would like him to have an assessment and get involved in some outpatient treatment and test as you deem fit, Mr. Coast.
Very good, Judge. Hey, Cade, when you get out, you're going to be back on green. And so you're going to start calling tomorrow. You do need to see me when you get out because I need you to sign a release so you could have that assessment done.
Yes, sir.
And then when you get out of jail today, I'm going to need you to come back and see the probation department on the 3rd floor. Mr. Jones, you want him just to report up here when he gets out today?
Yeah, that's fine, Judge. Just so he knows if he doesn't report, then we got bigger issues.
Okay, so when you get out of jail today, it might be around noon, 1 o'clock, whatever. They're open this afternoon. I need you to come there. I need you to set up a time to meet with them, and it's the 3rd floor probation department, okay?
Are you in the courthouse?
Right here, right across the hall from me. So on the 3rd floor, and then they're gonna get your information. If you do not show up today to them, understand I will issue a bench warrant.
I understand.
Okay, so you're gonna 1, report to the probation department this afternoon. 2, you're gonna start testing green again. And do you want him to stop by and see you this afternoon, Mr. Coast?
I do, Judge. I do need to see him.
Yep, so when you're here, you're gonna need to talk to Mr. Coast as well as the probation department, all right?
Yes, ma'am.
And then I will release you on a PR bond. Do you want that in person or Zoom sentencing, Mr. Hesper?
Zoom, Your Honor.
All right, we'll do a Zoom sentencing. And I have received back a signed copy of the advice of rights. So you are all set, all right? Good luck to you.
Thank you.
Don't disappoint me. All right. Mr. Goldstein is gone. Oh, Mr. Goldstein, you're here. Hold on, I got a cell phone in my Zoom room. So let's see if it's Dustin King. All right, I just admitted, where'd it go? Who's joining? Samsung device, and I'm sending you a request to unmute your device, please. Dustin King, are you in the courtroom? No. Okay. All right, I have somebody on a Samsung device. You just unmuted and started your video. What's your name, sir?
Dustin King.
Excellent. This is in the matter of the people of the state of Michigan versus Dustin Michael King. File number 25-22419FH. I have David Goldstein appearing on behalf of Mr. King. And Ms. McClure, are you my prosecutor today or are you on this file?
I am your prosecutor today.
Okay. And I have Phoebe McClure appearing on behalf of the people. Mr. Goldstein, this is date and time set for a pre-trial conference. How would you like to proceed today?
Well, Your Honor, these files have been sort of bouncing around, so I'm not sure exactly who the prosecutor is. I know it's not Ms. McClure. It was Isaac Sneed at one point.
It is still Mr. Sneed as far as I can tell.
Okay. Your Honor, if I can have a couple of weeks to talk to Mr. Sneed, he and I have been talking about resolution. We haven't come up with anything definite yet, but we've been talking.
So my next available is January 21. Are you available that day, Mr. Goldstein?
Let me take a look, Your Honor. Yes, Your Honor, I'll make myself available.
All right, so Mr. King, I'm going to set this for pretrial on January 21 at 8:30 in the morning. It's the same Zoom number you used today. So make sure you Zoom back.
I should be there that day. I apologize.
It's okay. You can appear via Zoom or in person. It's up to you, but it's the same Zoom number. So January 21 at 8:30. And Mr. Goldstein, can you do the stip in order to adjourn? And Ms. McClure, can please sign your name with permission?
I was actually going to just offer to do the stip in order and sign his name if that's easier, Mr. Goldstein.
Thank you, Ms. McClure. I appreciate it.
Yeah, I know.
Thank you,
Nice
Ms.
Christmas
McClure.
present. Thank you.
Can we sign your name?
Yeah, that's fine.
All right, excellent. You're all set, Mr. King. Thank you.
Thank you.
Thank you. Have a great day.
You as well. All right, Mr.
I'll try my
Shea.
hardest.
You're good. You can disconnect.
Thank you.
All right, Mr. Shea, let me get your client. There she is. Let me let her in. All right, so where'd she go?
She's on screen,
Mr.
Your Honor.
Witt, you have DeWitt, but I have you on this file as Schmidt. Do you prefer Schmidt, correct?
Yes.
Okay, this is in the matter of the people of the state of Michigan versus Holly Eileen Schmidt, file number 25-22261FH. I have John Shea appearing on behalf of Ms. Schmidt. This is an Allison Arnold file, but I have Phoebe McClure appearing on behalf of the people. This is the date and time set for a pretrial. I have a letter dated, I have one from November 3rd and obviously one from December 15 from Darren Coast, stating that Ms. Schmidt continues to blow twice a day on a remote breath device. She never misses and is always 0%. She has been on the machine for over a year now. So, Mr. Shea, how do you wish to proceed on the pretrial today?
Your Honor, when we were last in court, I advised, Ms. Arnold and I advised you that we were obtaining additional expert reports, which we have obtained, although they were just on Monday. My expert was caught up in trials throughout November. They've been shared with Ms. Arnold, and on Friday we have a meeting scheduled to meet Ms. Arnold and I with the MSP detective who did the accident reconstruction and with my expert. And following that, I anticipate that Ms. Arnold and I will have further discussions. So we are requesting an adjournment of the pretrial to, Ms. Arnold suggested the 21st or the 28th. It does not matter to me.
Okay, how about January 28th at 8:30 a.m.?
That would be great.
All right, so I'm going to adjourn the pretrial to January 28th at 8:30 a.m. Same Zoom number, Ms. Schmidt. And Mr. Shea, are you going to do the stip in order to adjourn? And Ms. McClure, can you sign your name with permission?
Yes, and if he prefers our office prepared, that I'm fine with that.
You know, you're
Ms.
setting
McClure,
a precedent, Ms. McClure. Now everybody's going to want you to do it.
Ms. McClure, you're very gracious, and I would appreciate it if you could. Thank you
That's
very
no
much.
problem.
Okay.
Can you
right.
sign your name with permission to that stip in order to adjourn?
Absolutely.
Okay.
Everybody have a great holiday.
You as well. Thank you.
All right. Take care.
All right.
Judge, what date was that put out to?
January 28th at 8:30 in the morning.
Thank you.
Thank you.
All right. So
All right,
Brian.
Holly, I'll give you a call.
Yep, Brian Fry. I have Sierra Gibson in my waiting room. I see the AG there, Mr. Wood, so we will get to those, but those are run to Underwood files and she always goes to Judge Olsaver first. So I'm getting Ms. Gibson's file. If you have a case in front of Judge Olsaver, Mr. Wood, you probably should go there first with Ms. Underwood.
I do not, Judge, and it's fine. I'll be ready when you are. I have another matter, Jordan Kramarczyk with Christopher Fleming, but I'm fine. I'll be ready when you are. Thank you, Judge.
Okay, thank you. All right, Ms. Gibson, can you start your video, please?
Yeah, I'm trying to get back to the screen. Okay.
It's okay. I'm going to send you a request. It might make it easier.
Okay.
You are Sierra Gibson though, correct?
Yes, ma'am.
There you are. All right. This is in the matter of the people of the state of Michigan versus Sierra Gibson, file number 25-22225FH. I have Douglas Hartung appearing on behalf of the people, and I have Brian Fry appearing on behalf of Ms. Gibson. I do have a letter dated December 15 from Darren Coast, my pretrial services coordinator, stating that she continues to do well with her testing. She has been free of cocaine for 4 months now, so that's great. I do have an advice of rights signed by her. So, Mr. Fry, what are we doing today?
So, Your Honor, I believe we have a plea agreement worked out in this case where my client, Ms. Gibson, would be pleading guilty to count 3, possession of cocaine. Count 1 and count 2 would be dismissed, and there would be no supplements as part of this plea.
Any other agreement?
No, Your Honor.
Is that a correct recitation of the plea, Mr. Hartung?
It is, Your Honor.
All right, so Ms. Gibson, can you go into the light?
Yes.
I know. Okay, good. Can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, Ms. Gibson, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 3, controlled substance possession of cocaine less than 25 grams, which carries a maximum penalty of up to 4 years in prison and or a $25,000 fine? So is it your intention to plead guilty to that count?
Yes, Your Honor.
Do you understand the remaining counts as well as any controlled substance, subsequent double penalty or subs would be dismissed at the time of sentencing? Do you understand that?
Yes, Your Honor.
Are you satisfied with Mr. Fry as your attorney and the advice that he has given you?
Yes, I am.
Good. Neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Hartung?
Yes, Your Honor.
Mr. Fry?
Yes, Your Honor.
And Ms. Gibson, is that correct as far as you're aware?
Yes, ma'am.
All right. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, sorry, take a breath. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, Your Honor.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, Your Honor.
Do you understand if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding, failing to appear for sentencing, violating terms of conditions on bond or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. I don't think that will happen. You're doing a great job right now, and I'm really proud of you. So
Thank you.
if you are, you're welcome. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given you, Ms. Gibson?
No, Your Honor.
All right, how do you plead to the charge that on or about July between the time period of July 29 of 24 through January 29 of 25, is that right, Mr. Hartung?
That is correct.
Okay, that you did knowingly or that you did commit the offense of controlled substance possession of cocaine less than 25 grams. Guilty or not guilty?
Guilty, Your Honor.
Okay, has anyone made any threats or promises to you to induce you to plead guilty to this charge other than the agreement on the record?
No, Your Honor.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promise or threat or inducement other than the plea bargain to induce the defendant to plead guilty? Mr. Hartung?
No, Your Honor.
Mr. Fry?
No, Your Honor.
All right. Has your attorney promised you any particular sentence or estimated what your sentence will be, Ms. Gibson?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
All right, so Ms. Gibson, during the time period of July 29 of 24 through January 29 of 25, was there a day where you were in the city of Adrian and the county of Lenawee?
Yes, Your Honor.
All right, and did you have in your possession less than 25 grams of the controlled substance cocaine?
Yes, Your Honor.
Did you know it was cocaine?
Yes, Your Honor.
Did you have any legal right to possess it?
No, Your Honor.
All right, Mr. Hartung, are you satisfied?
Yes, Your Honor.
All right, has the court complied with MCR 6.302 B, C, and D? Mr. Hartung,
Yes, Your Honor.
Mr. Fry?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights, and she does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I am going to refer this matter to the probation department for a pre-sentence investigation. And Mr. Fry, are you available on January 30th at 8:15 in the morning?
Yes, that'll work, Your Honor.
All right, so Ms. Gibson, I'm going to set this for sentencing on January 30th at 8:15 in the morning. So I'm going to, who's my probation officer today, Mr. Jones. So Ms. Gibson, I'm gonna pop you in a breakout room with Mr. Jones, and he's gonna give you some instructions. Make sure you show up at the meeting with the probation department and be truthful with them about your background, the events that occurred. They'll prepare a pre-sentence report. We'll get a copy of that to Mr. Fry. Mr. Fry will reach out and review that with you before the day of sentencing. And then would you like Ms. Gibson or Mr. Fry to appear via Zoom or in person? Or Mr. Hartung, do you have a preference?
I do not have a preference in this matter, Your Honor. Leave that to the court's discretion.
Mr. Fry?
I don't have a preference either. Sierra, do you have a preference?
No, Your Honor.
We're willing to
Do you
appear
live in, are you still living in Adrian?
Yes, ma'am.
Okay. So do you want to appear via Zoom or in person?
Zoom is fine.
Okay, so we'll do that via Zoom. All right, I am going to open up a breakout room for you and Mr. Jones. Mr. Fry, do you wish to join the breakout room?
I don't need to, Your Honor.
Okay, so Ms. Gibson, give me a moment. All right, you're going to get an invitation to join a breakout room and talk to Mr. Jones. He'll get your contact information, and then he will give you further instructions. And then we will see you back on that date for sentencing, and you continue your testing with Mr. Coast, okay?
Okay, thank you very much.
You're welcome. Go ahead and join that room, and then you're all set.
Okay, let's see.
Thank you, Your Honor.
Thank you. Is that all you had, Mr. Hartung?
In your court, yes. Thank you, Your Honor.
Okay, thank you. All right, so Charles, Diane Moliterno. All right, Mr. Malaro. Okay, he was in jail. Gary Bowerman, Todd Bowie. Hey, this is Judge Anzalone. I am ready for Gary Bowerman and Todd Bowie.
You said Bowie?
Yep, Bowie and Bowerman, yep.
All right, can do.
All right, thank you.
Yep, bye.
Bye-bye. I got a bunch of jail Zooms. Okay. So, is Trenton Baker in the courtroom?
Yes, ma'am.
Mr. Baker, why don't you come up to the podium? Mr. Malaro?
Yes, Judge.
All right, this is in the matter of the people of the state of Michigan versus Trenton Daniel Baker. File number 25-22487FH as Salvatore Malaro appearing on behalf of Mr. Baker. And I have Phoebe McClure appearing on behalf of the people. So this is a date and time set for arraignment in this matter. Mr. Malaro, do you waive the reading of the felony information?
Yes, Judge, at this point, we would waive the reading of the indictment in open court, or information, waive any defects of the time and place of service. My client would stand mute as to the allegations and ask that the court enter a not guilty plea. And we'd like to address some bond conditions, Judge.
All right, so I will enter a plea of not guilty on behalf of Mr. Baker. January 29, hold on, let me check my date. Is my next pretrial, is that too soon? Or January 28th?
January 28th is fine, Judge.
All right, Ms. Adams, could I get a notice of hearing for Mr. Baker for January 28th at 8:30 in the morning?
Yes, Judge.
All right, and okay, so Mr. Malaro, you wanted to address bond? He's out of jail,
Yes,
so that's a start.
Yes, Your Honor. So, Judge, this involves an incident involving Mr. Baker's brother. It was, I think, an unfortunate set of circumstances. However, Mr. Baker's been attending all court appearances, been very cooperative in regards to getting this matter resolved. He's been advised, and I think he's in the process of engaging with anger management. I'd asked if the court could consider, if there's no objection from the prosecutor's office, to remove the no contact provision with respect to his brother. And I would ask that perhaps on a condition B that there be no assaultive or, behavior involving anger on the part of Mr. Baker with respect to his brother. That would be
Is
a
his
request.
brother
Judge.
Brandon Peralt?
Yes, I believe so, Judge.
Okay, so Ms. McClure, I will, as I always don't know much about the case until a jury trial. What is your position on this?
Yeah, Judge, this was a more or less a disagreement between brothers, and unfortunately, Mr. Baker did decide to grab a firearm. I've spoken with his brother at pretty great length, and he's very conflicted on this because on one hand, he doesn't think his brother understands how serious this is, but on another hand, he doesn't want, him to be stuck with this felony because of his age. So we've talked at length about resolution. I've also spoke with the officer in this case, and I would highly encourage Mr. Baker to take advantage of the plea offer in this case because I don't do that very often on firearm cases, but I am offering him a plea to just brandishing a firearm. The brother he has filled out a request for dismissal on his part of the charges. So I do think, especially with the holiday coming up, he's fine with the no contact being lifted. But that being said, I would strongly encourage Mr. Baker to accept that plea offer. We obviously want, and I think it probably already is, to know that there's no possession of weapons or firearms while on bond or potentially probation in this case.
All right, okay, and so you're charged with carrying concealed, which carries a maximum penalty of up to 5 years in prison. Assault with a dangerous weapon, which carries up to 4 years in prison, and brandishing a firearm in public, which is a misdemeanor, which carries a maximum penalty of up to 90 days. So understand that people don't have to dismiss a charge just because a victim wants them to. I think Ms. McClure made that clear on the record. So you need to speak with your attorney about this plea offer, right? Use your words.
Yes, ma'am.
Say aloud.
Yes, ma'am.
Okay, so where are you living now?
With my grandparents.
Do they have any weapons in the home?
No, ma'am.
And where do you want to go? I mean, is that where you always live, or you don't want to go live back with your brother, do you?
No, ma'am.
Okay. All right. So Ms. McClure, you're saying,
So my understanding is the whole family lives with their grandparents at this house on Kopke Road. And I think the older brother, was he just visiting? But I think something like that.
He doesn't live there, right?
No, they live with my parents.
Okay, so maybe I have that wrong. I was under the understanding that the entire family lived at that Kopke Roadhouse. So,
okay.
I guess I just want clarification. Yeah, if he is going to be living with his brother or not. I thought they did all live together.
Okay, so you're not going to be living with your brother.
No, ma'am.
All right, I'm going to lift the restriction. You have a no alcohol clause?
No, ma'am.
Well, you do now. So I'm going to add a no alcohol because people do stupid stuff. You did stupid stuff without alcohol? I don't know, maybe, but so I'm going to put a no alcohol clause until such time as a please enter because it's the holidays. So I don't want you drinking and fighting like families do. So I'm going to add a no alcohol clause. Mr. Coast, have you met Mr. Baker before?
I have not, Judge.
All right, so I'm going to have Mr. Coast meet with you today and explain what's involved in a no alcohol clause. All right, I am going to bring you back as soon as I can, which would be January 28th. And Miss Adams, if I could, I think I already asked, but a notice for January 28th at 8:30.
Yes, and Judge.
Yes.
Could I get that brother's name, please?
The what?
The brother's name?
It's Brandon with an O, Brandon, Michael Peralt, Perault. So I'll allow you contact. If he's being stupid, you leave, right? Okay, use your words. All right, so I'm gonna set this over to January 28th at 8:30. When you leave here, you're gonna go out in the hallway and Mr. Coast is gonna come talk to you about whatever restrictions and testing he's gonna do for alcohol. How old are you?
25.
Okay, so, yeah, just can't drink during Christmas,
I don't
okay?
even drink alcohol.
Good, good. So, we'll get you a notice of hearing, so I have a seat behind you. Just right there.
Also, I do have a certificate here of completion for anger management.
Good.
So
Keep that, don't lose that, because you'll have to provide that to the probation department. So have a seat right behind you on that bench, and then we will get you a notice of hearing, and then Mr. Coast will come meet with you. All right. And Mr. Malaro, if he decides to accept the plea and you want to bring him in sooner, just let me know.
Yes, Judge.
Okay, so I have Mr. Bowerman. So lots of files, Mr. Bowerman. Get your files. So this is in the matter of the people of the state of Michigan versus Gary Scott Bowerman. File number 25-22242FH, 25-22243FH, 25-22277FH, 25-22469FH. Hold on. Okay. Can I be? So I'm talking about that language. All right. So I have a police report from the Adrian Police Department dated November 14. Just to let you know, that's been provided to the court. It's like you have police contact or new charges. All right. So I have Mr. Malaro appearing on behalf of Mr. Bowerman and Phoebe McClure appearing on behalf of the people. So Mr. Malaro, how would you like to proceed?
Judge, I think this is all for like a contempt and a pretrial, I believe. Yeah.
Yes.
Okay. So Mr. Bowerman was in a rehab and then went to transitional housing. I know Gary very well. It's kind of breaks my heart. He just has so much trouble staying clean. However, Mr. Bowerman is never going to give up trying to get clean and stay clean. He'd asked if the court would consider adjourning this matter for an additional pretrial, but also to allow Mr. Bowerman to enter rehab if we can perhaps arrange it. That would be our request.
Ms. McClure, any position?
I have down that he did do an inpatient in October. Is that not true?
He's done inpatient quite a few times.
Oh, okay. I guess we'll leave it up to your honor's discretion.
All right, so Mr. Malaro, I do appreciate and I do respect that Mr. Bowerman wants to continue to work on his sobriety, and I do believe he does. Mr. Bowerman, I also have known Mr. Bowerman probably since he became an adult, and I know that this is something he wants, but I also know he has a tendency to dip out on me, and I think you have, Mr. Bowerman, and you.
One time, Your Honor, I won't do that again. I promise you. That's why I did.
I know, it's what you
Or the
told me
last time. It was
So
only once.
I'm
I didn't
not-
do it the last couple of times, Your Honor. You said
Okay.
you were gonna put me in one that I needed it last time. Sorry to cut you off, Your Honor. You said that you agreed that I do need it and I could do this. And it does take a couple of times. I've realized too, going through these places to get it. And I fully believe wholeheartedly that I can do this without a doubt. And I know where I went wrong. You said you'd give me long term, and I believe I need that and deserve that over prison, Your Honor, please.
I know. But at this time, I'm not going to release him on bond. I definitely will, considering the future rehab facility, but I don't know what the plea offer is in this file. I don't know what he's facing. So I'm not comfortable at this time releasing him, so I'm going to leave bond the same. How far out would you like a pretrial, Mr. Malaro?
Given that, Judge, I'd say maybe 2 weeks, 3 weeks at the most.
My next available is January 28th at 8:30 in the morning.
That's fine, Judge.
You'll do the step in order to adjourn, Mr. Malaro?
Yes, I will do that.
And I've made a couple different plea offers in this case, but they don't encompass all the cases because they all came in at different times. So I'll work on getting some sort of global over to Mr. Malaro before the next pretrial.
Thank you.
Thank you, Ms.
All right.
McClure.
So we'll be back then on January 28th at 8:30. Thank you, Mr.
Thank you all.
Bowerman.
Have a good day.
You too, Mr. Bowerman. All right, Mr. Bowie, I do have your attorney, so give me a second, Mr. Malaro, and I'll skip back to you. Diane Malaterno, I believe you represent Mr. Bowie.
Morning, Your Honor, that is correct.
All right, this is in the matter of the people of the state of Michigan versus Todd Jerome Bowie, file number 25-22401FH. I have Diane Malaterno, Diane Malaterno appearing on behalf of Mr. Bowie and Alexander Bayonetto appearing on behalf of the people I do have in my file. I have a plea agreement. Miss Malaterno, were you able to get an advice right signed by your client or no?
I was not, Your Honor.
All right, so we will need that. So Mr. Bowie, we're gonna send over to the jail a copy of your advice rights. I'm gonna go through those rights with you today. But when you get it, read it and then sign it and they'll send it back to us, okay?
All right.
All right, so the plea agreement I have received states that Mr. Bowie will plead to count 1, which is failure to comply with reporting duties, which is a high court misdemeanor carrying a maximum penalty of up to 2 years in prison and or a $2,000 fine. And the habitual offender fourth offense notice, which would have made this a 15-year felony if convicted, would be dismissed. And there is a sentence agreement and no further jail, so we can address bond today. Is that a correct recitation of the plea, Ms. Malaterno?
That is correct, Your Honor.
Mr. Bayonetto?
Yes, Your Honor.
All right, so Mr. Bowie, is Mr. Bowie going to accept the plea?
Yes, Your Honor.
All right, Mr. Bowie, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, Mr. Bowie, you've heard me read the plea agreement and your attorney agreed to it. Is it your intention today to plead to count 1, failure to comply with reporting duties? So is it your intention to plead guilty to that today?
Yes.
Are you satisfied with Ms. Malaterno as your attorney and the advice that she has given you?
Yes.
All right, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed a possible sentence with the court other than no further jail. Is that correct, Ms. Malaterno?
That is correct, Your Honor.
Mr. Bayonetto?
Correct, Your Honor.
And Mr. Bowie, is that correct as far as you're aware?
Yes.
All right, so Mr. Bowie, if a guilty plea is accepted, there will be no trial. This means that you'll be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand, Mr. Bowie, if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Bowie?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
Do you understand that if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating terms of conditions on bond or the terms of any sentence or plea agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Let me look at something real quick. All right, this doesn't have any registration penalties with it, just the other, because there's already a requirement to register. Do you have any questions about the rights that I've given you, Mr. Bowie?
No.
Okay, so Mr. Bowie, how do you wish to plead to the charge that on or about May 18 of 2025 in the city of Adrian in the county of Lenawee that you failed to comply with reporting duties under the Michigan Sex Offender Registration Act? Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Malaterno?
No, Your Honor.
Mr. Bayanetto?
No, Your Honor.
Mr. Bowie, has your attorney promised you any particular sentence or estimated what your sentence will be in terms of probation and fines and costs?
Yeah, sir. No.
Say that again for me, Mr. Bowie.
No.
Okay, is it your own choice, or I'm sorry, is it your own choice to plead guilty?
Yes.
All right, so Mr. Bowie, you are required under the Michigan Sex Offender Registration Act to verify your address by reporting in person and providing proof of residency at either probably the Michigan State Police Post or APD. Is that true?
Yes.
And were you supposed to do that by May 18 of 25?
Yes.
And did you fail to do that?
Yes.
Okay. Has court complied with MCR 6.302 B, C, and D? Mr. Bayanetto?
Yes, Your Honor.
Ms. Malaterno?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the agreement of, I believe it was, no further jail. So I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Bowie, are you on probation?
I don't know if I am or not.
Your Honor, honestly, we don't know. There's some confusion on his district court cases that I need to look into and we'll be doing in the next week.
Okay. All right. So Mr. Bowie or Miss Malaterno, you want to address bond?
Yes, Your Honor. He is currently being held on a sentence out of district court that the judge is willing to review. So on this case, we would just ask for a very minimal bond for Mr. Bowie.
Okay. Oh, okay. So, all right, Mr. Bowie, I'm gonna set bond at 500 on this, so you're getting some credit, okay?
Okay.
So I will have to schedule this for a pre-sentence interview. Miss Molitano, are you available for sentencing on January 30 at 8:15 in the morning?
Yes, brother.
All right, so I'm sorry, January 30th at 8:15. And hold on. No. All right, and Mr. Bowie, you want to appear in person or via Zoom?
In person.
All right. So Mr. Jones, he's currently in custody. Do we know an out date, Ms. Moliterno?
Honestly, Mr. Bowie probably knows that better than I do. Or
Do you have an out date, Mr. Bowie?
I'm not sure when it is.
Okay, so tell you what, at some point, if you're in jail, the probation department's gonna reach out to you to do a pre-sentence report. When you talk to them, be truthful about your background, the events that occurred. We'll provide a copy to Ms. Moliterno. She will review that with you before the day of sentencing. If you get released and you have not talked to circuit court probation, that day or the next business day, I need you to come to the 3rd floor of the courthouse to the circuit court probation department, and they'll give you the packet and a date and time to meet with the probation officer, all right?
All right.
And just be truthful with them about your background and the events that occurred. All right, thank you, Mr. Bowie.
All right.
Thank
Thank
you.
you, Your Honor.
Thank you. All right, Mr. Daly, I have Claude Howard.
Yes,
Do you want to move the microphone? All right, I'm gonna move that microphone for you because our mics are not working very well. Claude Howard, all right, you gotta sit down because you're gonna give me like vertigo. Okay. Let me pull his file. This is in the matter of the people of the state of Michigan versus Claude Jalen Howard III, file number 25-22458FH. I have James Daly appearing on behalf of Mr. Howard. Always good to see you, Mr. Daly. And I have Phoebe McClure appearing on behalf of the people. Is this your file, Ms. McClure, or just covering it?
It is Miss Arnold's, but I have all the plea information.
All right. So, Mr. Daly, I have a couple things. So I have December 15, Darren Coase from Pretrial Services provided a letter that states Mr. Howard has been testing with him at the courthouse. He only tests positive for THC. He did present a valid medical marijuana card, and he always presents with a positive attitude. That's noted just because a lot of people don't. So we always appreciate happy people. So I have a plea agreement as well that Mr. Howard III is going to plead to count 1 and count 3. I don't have, let me see, is there an amended information? Yep, there we go. So he's going to plead to count 1 and he's going to plead to count 3. Count 2 would be dismissed, and probation with up to 1 year in jail. So the court has, and that's up to the court whether or not he has a jail term or not. So that's why it says up to 1 year, Ms. McClure.
I'm guessing so.
All right.
Yeah.
So
And-
it doesn't say with 1 year in jail, it says up to 1 year in jail. So that gives me discretion to give them up to 1 year in jail. Is that correct, Mr. Daly?
It's my understanding that originally there was going to be no upfront jail time.
Okay. Well, it says up to,
And Judge,
that
the
correct?
controlled substance second offense is also being dismissed pursuant to the plea. So count 1 is just the 4-year.
Okay, excellent. All right, so that'd be a 4-year and a 2-year. So is that a correct recitation of the plea, Mr. Daly?
It is, Your Honor.
So Mr. Howard, do you want to raise your right hand for me? Do you
Sure.
solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, and once again, can you state your full name for the record?
Claude Jalen Howard III.
All right, thank you. So Mr. Howard, I have read off of the plea agreement form and there's been discussion on the record. So is it your intention then to plead guilty to count 1, controlled substance, delivering, manufacture of marijuana, which carries a maximum penalty of up to 4 years in prison and or a $20,000 fine, as well as count 3, police officer fleeing 4th degree, which carries a maximum penalty of up to 2 years in prison and or a $500 fine and a 1-year license suspension. So is it your intention to plead guilty to those 2 counts?
Yes, it is, Your Honor.
All right. Are you satisfied with Mr. Daly as your attorney and the advice that he has given you?
Yes, I am.
Neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed a possible sentence with the court other than in the agreement. Is that correct, Mr. Daly?
It is, Your Honor.
Ms. McClure?
Correct, Your Honor.
Is that correct, Mr. Howard?
Yes, it is.
All right. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Sir, do you understand if your plea is accepted, you will be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Howard?
Yes, I do.
Okay. So I have 2 screens that say Howard, and I don't think, I think I did, you're 2 different people, and I screwed up earlier when I entered dates. So Claude Howard is sitting in front of a picture on a wall with glasses, and then I have another guy with a different beard, sitting on a couch. What is your name?
Nathan Lawrence.
Say it again.
Nathan Lawrence.
I'm so sorry. I think I knew I had entered a wrong name earlier, but I couldn't figure it out. All right. So Mr. Lawrence, who's your attorney?
Rhonda Underwood.
Okay. So Ms. Underwood is down the hall still. So let me change your screen name. I'll pop you back in the waiting room. I'm so sorry, Mr. Lawrence.
That's okay, man.
Okay. All right. And Mr. Howard, do you understand any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, I do.
All right. And Mr. Daly, will you be able to get an advice of rights signed by him?
We've already had one signed. It was sent someplace.
Okay. Well, we'll find it. All right. So, Mr. Howard, do you understand if the plea is accepted and you engage in any misconduct as defined in MCR 6.310 between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, hold on a second, absconding or failing to appear for sentencing, violating terms of conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization.
It's not in your notes.
Mr. Malaro, go mute yourself, please.
Sorry, Judge.
Please, it's okay. All right, so Mr. Howard, do you have any questions about the rights that I've given to you?
None that I can think of.
Okay, good. All right, so how do you wish to plead to the charge that on or about October 8 of 2025? So Ms. McClure, do you have city, township, village?
It would be Madison Township, Your Honor. Sorry that that's not reflected on the information.
Okay, can they fix that?
I will have Ms. Arnold fix that, yes.
Okay, in Madison Township in the county of Lenawee, that you did commit the offense listed under count 1, controlled substance delivery, manufacture of marijuana. Guilty or not guilty?
Guilty.
And count 3, police officer fleeing 4th degree. Guilty or not guilty?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to these charges?
No.
All right. Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, I do.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Daly.
Your Honor, the other thing I would add is there is a civil forfeiture proceeding involving over $7,000. That matter has been resolved between Mr. Howard, myself, and the prosecutor's office. It's not part of this, but I thought it would be best to put that on the record.
Very good. Ms. McClure.
I agree. We do have a signed forfeiture paperwork.
Okay. Has your attorney, Mr. Howard, promised you any particular sentence or estimated what your sentence will be in terms of length of probation, fines, and costs, and so forth?
No, not yet, Your Honor.
Okay. Is it your own choice to plead guilty?
Yes, it is.
Okay. So, Mr. Howard, on October 8th of 2025, were you in Madison Township in the county of Lenawee?
Yes, I was.
And did you have in your possession marijuana?
Yes, I did.
And did you possess it with the intent to deliver it, either give it to somebody or sell it to somebody?
Yep, I did.
Okay. All right. And then at that same date and time, were you actually driving a motor vehicle?
Yes, I was.
Okay. And at some point you came in contact with the sheriff?
Yes.
All right. And was it daytime or nighttime?
Nighttime.
And did he try to pull you over?
Yes.
Now, at some point, you either didn't pull over and drove off for a while, or you pulled over and then you drove off. So when he gave you a signal, was it the lights on his car?
Yes.
All right. Did you pull over?
No.
Okay. And you knew he was a police officer and he was trying to pull you over?
Yes.
Okay. And how far did you ever pull over? Or did you just keep going?
Kept going until we stopped.
Okay. All right. Are you satisfied, Ms. McClure?
I would just ask us to count one, Mr. Daly and or Mr. Howard. Do you agree that that possession with intent to deliver was not in compliance with either the Michigan Medical and or Recreational Marijuana Act, and either by amount and or licensing?
We'll stipulate there was no legal justification for him to have the amount of marijuana that he had.
How much did he have?
I think it was over 20 pounds.
Okay. All right. Would you agree, Mr. Howard, you weren't in compliance with the laws requiring selling of marijuana?
Yeah.
People are
Okay.
satisfied, Your Honor.
All right. Has court complied with MCR 6.302 B, C, and D? Mr. Daly?
Yes, Your Honor.
Ms. McClure?
Yes, Your Honor.
I accept a plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Daly, are you available for sentencing on January 30th at 8:15 in the morning?
January 30th?
Yes, sir, at 8:15.
Yes, Your Honor.
All right. So, Mr. Howard, I'm going to ask that you come in person, not because you're going to jail that day, but just because there'll be some discussion. All right. And so Mr. Daly believes part of your jail, and he'll get that put in writing, or we'll take care of that. But you're downriver, right?
Yeah.
Yeah. And I swear all the downriver people, me too. But we will set this for January 30th at 8:15 in the morning. And I'm going to ask that you be here in person, okay?
All right.
All right. And Mr. Howard, I'm going to put you in a breakout room with Chris Jones from the Michigan Department of Corrections. Mr. Jones is going to give you some direction and information. One, he'll get your address and your contact number. Two, he's gonna give you a date and time that you're gonna have to meet with the probation department. You probably have to come in person for that. When you meet with them, be truthful about your background and the events that occurred. And Mr. Jones or whoever's assigned to your file will prepare a pre-sentence report. And then we'll provide a copy to Mr. Daly. So make sure you reach out to Mr. Daly a week or two before sentencing. He'll probably mail you a copy of it and then he'll review it with you. And then we'll see you back January 30th at 8:15, okay?
Okay.
All right, so I'm gonna send you an invitation to join a breakout room. And where's Mr. Jones? Yeah, I'm from Wyandotte. Well, I was raised in Wyandotte. All right, there you go. Join that breakout room.
All right. Thank you.
Judge, I'm
Yes.
working from home today because my son's home from school sick. I'm gonna step
I
away
know
from
your
my
tree's beautiful, by the way.
Thank you. I just need to step away from my computer for a few. I know Mr. Bandetto's on. I'm sure he can
Okay.
cover for a few, but I should be right back.
Okay, not a problem. All right, So I know you're here, but Mr. Glazier goes to Judge Olsaver first, and then he comes to me second. Okay, so I'm not ignoring you. All right, I don't have
Judge?
Rhonda. Yes.
Judge, if I may, I'm covering Mr. Glazer's cases for him this morning.
Oh, well, you didn't tell me that. Okay. That's good to know. So let me get back here. I have. Chris Fleming. So let me take Kramarczyk real quick, but then I don't have Rhonda yet on Lawrence. All right, Mr. Wood.
Good morning, Your Honor.
Find Kramarczyk. Jenkins.
Good morning, Your
All
Honor.
right. Good morning. So this is in the matter of the people of the state of Michigan versus Jordan Alexander Kramarczyk, file number 25-22434FH. I have Christopher Fleming appearing on behalf of Mr. Kramarczyk, and I have Mitchell Wood appearing on behalf of the Assistant Attorney General. So this is a date and time set for a pretrial. Mr. Fleming, how do you wish to proceed?
Good day, Your Honor. Chris Logan on behalf of Mr. Kramarczyk. Your Honor, just would be requesting more time. I know in talking with the Special Assistant Attorney General, Mr. Wood there, Mr. Kramarczyk did indicate to me that once he gets paid, he's going to make the monthly payment of, I think it's $358 if memory serves me correctly. But essentially, Judge, we're looking for some time to get this paid off as much as we possibly absolutely can. So just would request an adjournment to, it looks like January 28th, if we could, in the morning there.
Any objection, Mr. Wood?
Judge, no, Mr. Fleming and I have been communicating by email here, and he indicated to me when Mr. Kramarczyk bonded out in September, he paid a large cash bond, $7,086. That money has been paid over the child support case. It was paid over in September. The problem is he hasn't paid anything since. So he's got one child, 8 years old. He's got a $358 a month obligation. Paid nothing in October and November. So Mr. Fleming said he's starting a new job and he'll be paid. We want to see him pay the $358 in December because he can't be out on bond and then still committing these crimes of not paying child support. So
right.
I'm okay with an adjournment to the 28th, Judge. But again, if we come back on the 28th and he didn't pay in December, and by then he should have paid in January as well. I'm assuming whoever covers it at that time will be asking for a remand.
So what's the arrearage total, Mr. Wood?
The arrearage, Judge, right now is $21,016.87.
All right. So Mr. Kramarczyk, here's the deal. I just had a guy pay off $40,000 in child support on a felony child support case. He got a second job. He worked his butt off. He was doing stuff. So you're out of jail to make payments, right? So understand, if you got to get a second job, you got a shovel, I don't care what you do, you need to pay your bare minimum and be hammering down on the arrearage as well. So you're paying the bare minimum and another 100, 150, 200 bucks if you can on the arrearage to show us good faith, because otherwise your bond will be revoked. So Mr. Komarchik, it's very important that you're making those payments every week, every paycheck, start hammering money on this. And if you got to get a second job, do it, because that's what these guys, and it's mostly guys. So there's some women, but mostly men, but you need to be making these payments. Got it, Mr. Komarchik?
Yes, Your Honor.
Okay. So if we come back in January, on January 28th, you haven't made any payments, I'm probably gonna revoke your bond. So January 28th at 8:30, Mr. Fleming, you're going to do the stipend order to adjourn. Mr. Wood, can you sign your name with permission?
I would appreciate that.
Okay, thank you, Mr. Fleming. Good luck, Mr. Komarchik.
Thank
All
you,
right.
Judge. Thank you, Ms. Wood.
All right.
Thank you, Mr.
Mr.
Fleming. And I'll be ready
Rosencrantz, why don't you
when
come on
you
up?
are, Judge, on the Lawrence matter.
Yep, I just don't have Brenda yet. All right, Mr. Malaro, you said you're covering for Mr. Glazier. I do have
Correct,
Mr.
Judge.
Rosencrantz. Let me grab his file. So. Right, this is in the matter of the people of the state of Michigan versus Craig Barrett Rosencrantz, file number 25-22459FH, 25-22460FH. Mr. Rosencrantz is usually represented by Mr. Glazier, but Mr. Malaro is covering for Mr. Glazier today. Mr. Rosencrantz, I'm not going to put the specifics on, but I did receive a letter through Linda Albright from the Public Defender's Office with a letter from a Derek Brown. Okay, is that a yes?
Yes.
Okay, are you still living in Ann Arbor?
No. Well, I mean, I'm going back there.
Going back there?
Yeah.
Okay, when are you going back there?
The intake date is the 7th.
Of January?
Yeah, that's like the latest. If somebody leaves in between then, I'm next to go, so.
Okay. Is that for the inpatient program or the aftercare?
Inpatient.
All right. Okay, so, very good. Is there anything we can provide in terms of services for you now?
No.
You good?
Yeah.
Okay, all right, so, all right, so, and then, are you testing as part of your bond conditions or through them?
Through,
Anybody?
not right now.
You're not testing right now? Okay. Okay. So I originally showed Darren Coast came over to the jail to see you for your bond conditions.
Yes.
And but you thought Washtenaw had a holder on you. Have you taken care of Washtenaw?
So I got, Mr. Shand is gonna be helping me out in there, and my probation officer there is also on the board of the farm. Both of them told me to take care of it when I get back into the farm.
Is there a warrant?
Yeah. Yes.
Not out of us, but out of Washtenaw.
Right, yeah.
All right. Mr. Coast, are you with me or are you?
I am, Judge.
So you had originally gone to see Mr. Rosencrantz at the jail. Was that because they had ordered bond conditions?
Judge, was it a pretrial assessment? I can't remember.
Judge, if I may,
Yeah.
Judge, the notes say he was
Oh, it
screened
was.
for
It was a
drug
pretrial
court and
assessment.
eligible. It says he's
Sorry,
screened for,
hold on, everybody stop talking real quick. So Mr. Coast, it was an assessment that you went there for. Okay, now go, Mr. Malaro.
Judge, the notes say that he was screened for and deemed eligible for recovery court. I
Yeah,
don't
he
know if
was.
if we're
But we
going to do
haven't seen
something on
him,
that.
so, yeah, but he was supposed to reach out to Sarah and like, I know you probably didn't realize it because that look on your face, was, I didn't know that. So because of this, we usually like testing and at least have contact with you through the recovery court program. If you're still, you know, I know you're gonna go to inpatient and do all that, but then when you get out. So Mr. Jones, is Miss Teskey here today?
I don't think I've seen her, but I can run down there real quick.
No, it's all right. All right, so,
I actually meet with the clinician at cafeterias today at 1.
today at 1?
Yes.
Okay, so I want you to follow up with that and with Sarah until you go off to Dunn Farms, okay? So, when do you want this adjourned to, Mr. Malaro?
Anytime after the first year, Judge. I think Mr. Glazer's expected back by then.
About, and Miss Adams, I'm gonna need a notice of hearing. Because I want you to go there and I want you to get settled in. How about February 4 at 8:30? They'll Zoom you in, they always do. Okay, so Miss Adams, February 4 at 8:30. And could I get a notice of hearing from Mr. Rosencrantz on both of these?
Yes, Judge.
Okay, and we'll get you a notice of hearing and then you know the drill, but when you get there, make sure you sign a waiver. So Sarah Teskey and everybody can verify where you're at and what you're doing. You look healthy, so you look good. I like to see that, and you have a good Christmas. And make sure you make that appointment today, all right? Okay, so I have a seat right behind you, and then my assistant will get you a notice of hearing, all right?
Thank you, Judge.
Thank you. Okay, so let me look at my list. I want to skip over to Miss Underwood real quick so we can get rid of Mr. Sinclair. I probably let you in by mistake. It'll just be a minute, all right? Nathan Lawrence. So I can get Mr. Wood out of here. JKL.
I just turned my video on, so you know I was back, but I'll turn it back off because I'm not on this case.
Okay. Okay. So Miss Underwood, I have Mitchell Wood from the AG's office, and I just admitted Mr. Lawrence. So this is in the matter of people of the state of Michigan versus, where do we find them? GHIJK. There we go. The matter of the people of the state of Michigan versus Nathan Edward Lawrence, file number 25-22395FH. And Mitchell Wood appearing on behalf of the AG today, and I have Rhonda Underwood appearing on behalf of Mr. Lawrence. Says the date and time set for a pretrial conference. So, Miss Underwood, how would you like to proceed?
Your Honor, I've spoken to my client. It's my understanding he's making his $500 payments every month. So I would ask for an adjournment in this matter of some 60 to 90 days, Your Honor, to keep building his payment history.
All right, Mr. Wood?
Yeah, I have no objection to that, Judge. He doesn't have an ongoing order in this case, and the arrears are below 10,098.81.70. But again, as Ms. Underwood said, he's been paying as ordered. He didn't pay in November, or I mean, he's been paying $500 a month. So I have no problem with an adjournment. It looks like hopefully we're on track, Judge, to do the standard tiered agreement that the AG offers. So I'm okay with an adjournment.
All right, so Miss, how far out, Miss Underwood?
Probably 90 days, Your Honor, we can do.
All right, how about March 11 at 8:30 a.m.?
I will prepare the stip in order with Mr. Wood's permission.
All right, so Mr. Lawrence,
Sign my
write
name.
that
Thank
down.
you very much.
Yep, write it down, March 11 at 8:30 in the morning. Keep making those payments. Thank you.
Yes, ma'am.
All right, bye-bye.
Thank you, Your Honor. Happy holidays. Thank you, Rhonda. Happy holidays to you.
Happy holidays to you too, Mitch.
Thank you.
All right, whoops. Hey, this is Judge Anslone. So I'm ready for Cody Gage. And let me see if I have anybody else. I think that's it. I'm ready for him, and I think that takes care of all my jail people.
All right, great.
All right, thank you. Bye. Okay, so.
Your Honor, do we have Mr. Tyndall?
We do, but I'm not done with Mr. Malaro. So I gotta go back to Mr. Malaro because I'm still working on his, and then I'll go to you, okay?
Thank you.
All right, Malaro is Mr. Glazier now. Oh, shoot. We need Anthony Hayback. If I ask for Haybecker. This is Judge Anslone again. I also need Mr. Haybecker. So Haybecker and Gage.
Okay, can do.
All right, thanks. Bye. Dailies,
I'm on Gage, correct?
Yeah, I think so. Yeah. Mr. Malaro, you covering for Knoblaw?
Your Honor, I have Jenkins, Baybecker, Canablo.
All right. Is Daniel Knoblaw in the courtroom? Want to come up to the podium? There you go. Yep. And then just move that microphone as you need to. This is in the matter of the people of the state of Michigan versus Daniel Mark Knoblaw, file number 25-22389FH. I have John Glazier appearing on behalf of Mr. Knoblaw, but Mr. Malaro is here in his stead. And I have Phoebe McClure appearing on behalf of the people. This is the date and time set for a pretrial. Mr. Malaro, how would you like to proceed today?
Judge, I'd ask to adjourn the matter. The note says that there is a plea that Mr. Canablo needed to talk to Mr. Glazier about. I don't see if that's occurred, so that's the basis for the request.
All right, Ms. Adams, I'm going to set this out to February 4 at 8:30. Could I get a notice of hearing for Mr. Canablo? So I'm going to set a pretrial for February 4 at 8:30 in the morning, and we'll get you a notice of hearing. If a plea agreement is reached, Mr. Malaro, could you leave a note for Mr. Glazier that I'd rather bring him in earlier? That'd be great.
Yes, I will do that, Judge.
All right, so Mr. Knobloch, you can just have a seat right behind you. We'll get you a notice of hearing, all right?
And Judge, I just want to make a record that according to Mr. Sneed's notes, the plea form was emailed on October 19th.
All right, excellent. Thank you. All right. Who do I have in the jail with glasses? What's your name?
Cody Gage.
All right. Hold on 1 minute. Glazier. Jenkins is at 10 o'clock. Motion. All right. Miss Underwood. All right. So Mr. Malaro, all I show left for you is Haybecker. You said Sinclair. Did you say Sinclair?
Jenkins, said Jenkins.
I
have a Brian Jenkins and a Anthony Haybecker.
Jenkins? H-I.
Says it's set for 10 o'clock, Judge.
Oh, yeah. Okay. All right. So we're waiting on Haybecker, but I have Gage. So let me get him. All right. This is in the matter of the people of the state of Michigan versus Cody Wayne Gage. File number 23-21257FH, 24-21921FH. Rhonda Underwood appearing on behalf of Mr. Gage, who's joining us from the jail. And I have Oh, Mr. Jones appearing on behalf of the probation department. So, Ms. Underwood, how do you want to proceed on this probation violation?
Your Honor, Mr. Gates has been charged with new felonies. So I think we're going to have to adjourn this.
All right, does he have a court date on those new charges?
Cody, do we have a court date yet?
Yes, I have the 22nd and the probable cause on the 22nd and then preliminary on the 29th.
All right, so I'm gonna set this over to February 4 at 8:30 in the morning for a pre-trial on this. And then obviously, Ms. Underwood, if something happens and it got adjourned or whatever, you can always call and move this date if you want, or bring them in sooner, all right? So, Mr. Gage, I'll continue your not guilty plea and we'll see you back on February 4 at 8:30 in the morning, all right? Your bond's continued. Okay, so I got the jail. Let's take Mr. Tyndall. All right, are you with me, Mr. Tyndall?
Gaishan?
Yes, ma'am.
There you go.
All right, this is in the matter of the people of the state of Michigan versus Skyshun Tyndall, file number 20-20027FH, 22-20717FC. Forget his name. This is a date and time set for a probation violation, pretrial, and a bench warrant. Bench warrant out. So, Ms. Underwood, how would you like to proceed today with Mr. Tyndall?
Your Honor, can we have, I talked to Mr. Tyndall this morning. He's got some things in the fire. Can we have a adjournment on this matter, Your Honor?
January 28th or February 4?
February 4 is fine.
All right, so
Judge, we still have a bench. There's a bench warrant going on right now with him.
All right, there is a bench warrant, Ms. Underwood. Do you understand that?
Mr. Tyndall.
That's what I'm trying to take care of, man. This $800 check should be in.
He has one in district court
Yeah.
as well as us.
And downstairs. Yes, ma'am. Yes, ma'am.
And he's not reported. I haven't seen him. He shows up to court.
That's the only reason why. I'm so sorry. There ain't no excuse.
Hold on,
That's all
everybody,
right.
stop talking. Ms. Tyndall, Mr. Tyndall, when we were here last time, I told you you had to report to Ms. Holly.
Yeah, I have that upstairs warrant too that I did not know about. So I have to pay for both upstairs and downstairs. So that I just really need it until next week. But February is fine. I just need it until next week, and probation will be paid off too. I'm waiting for this $800 check to be here.
We talked about the upstairs bench warrant the last court date, so you're aware.
Yeah. I know, I'm aware. That's what I'm just saying. It's just more money that I have to pay for downstairs and upstairs.
It's not a money matter, Judge. He's just not reporting.
Hold on.
Yes,
So
ma'am.
I'm trying to find the warrant. What's the date of the warrant upstairs, Ms. Holly? Oh, it's the November 4 one, right?
Yes, ma'am.
All right, so our warrant is because you failed to report.
And that's because I have the warrant.
Hold on,
downstairs.
let me talk, Mr. Tyndall, and then you failed to pay fines, costs, and restitution. You owe $838. And then the second violation is because you got pulled over for driving on a suspended. And we did arraign him on this, Miss Underwood, and we entered a plea of not guilty. But I told him to report, and he
Yes, ma'am.
hasn't. And obviously he has warrants, Miss Underwood, in district court and circuit court.
Gaishan,
No, yes.
we can get your case adjourned, but you have a warrant. You're going to go to jail if you get picked
And
up.
that's the reason why I haven't reported, because I have those warrants. There's no excuses to them. There's no excuse.
Right, here's the deal, Mr. Tyndall, I'm gonna set this over to January 21 at 8 a.m. or 8:15 a.m. January 21 at 8:15 a.m. And I know Christmas is coming and nobody wants to be in jail for Christmas.
Right.
Mr. Tyndall, on what, is that the total restitution and fines and costs owed on his files, Miss Holly?
Whatever the warrant says, I'm not sure anymore.
All right, and that's for both, let me see. So, Mr. Tyndall, I
Yeah.
mean, we do have always treated you fairly.
Yes, always.
So, here's what I'm gonna do. On file number 20-20027 FH, I'm gonna set your bond in the amount of $838.
Okay.
Hold on. 27 FH, $838.
Okay.
Okay, and then on file number 22-20717 FH, I'm gonna set your bond in the amount of 198, and those are cash.
Okay. Okay.
That's cash, not percentages, that's cash.
Yes, ma'am.
So what I will tell you is if you march in this courthouse and you pay this, I will quash the bench warrant, all right?
Perfect.
So that's all you gotta pay to get out of jail. So if you come in and you see Miss Holly and you hand her $838 and $198 and you pay this off, I'll quash the bench warrants on my file, both of my files, but I don't know what's going on in district court. But
Yes.
I do know that you bring that money in and you report to Miss Holly, all right?
Yes,
But
ma'am.
we'll see back on January 21 at 8:30 in the morning. And then, like I said, if you come in, when you get that check, I will quash the bench warrant right away, all right?
Thank you
I
so
think at
much.
this point, Judge, I wish we would just say, turn yourself into jail because this is playing games. He comes to court over Zoom every time, and it's been going on for too long.
Yes, ma'am.
I understand.
I would have been came in. Like I said, I just didn't want to do jail time, Miss Holly. You know,
Mr. Tyndall, January 21 at 8:30 is your next court date. As soon as you got the money, I want you to march into this courthouse and pay it. If you get picked up, you better have someone post that as your bond, okay?
Yes, ma'am.
All right. Yes.
I think because those warrants are in lien, we'll need to recall those and have the warrants reissued to change the bond.
Okay. Okay, we will do that. All right, Mr. Tyndall, thank you. Okay. Trying to keep good notes. Okay. All right, let's see what happens on that. All right. So who do I have at the jail? What's your name, sir?
Anthony Habecker.
Okay, Mr. Wayne Scott, is Mr. Mawad still your attorney or no?
Yeah, you said that he'd be here on Zoom this morning.
All right, step out and call him.
I can't, I was saying, no.
Becky, could we try reaching out to Mr. Mawad, please? Or if anybody can text him on Wayne Scott, that would be awesome. I don't have his number.
I can
All right,
text him,
matter.
Judge.
Okay,
He
thank you.
resigned. He resigned
Hold on,
from my
Mr.
case. Okay.
I'm not talking to you, Mr. Haybecker. I'm talking to Mr. Wayne Scott. I'm sorry. All right, this is in the matter of the people of the state of Michigan versus Anthony Scott Haybecker. File number 24-21817 FH, 24-21818 FH, and 24-21819 FH. Mr. Haybecker, you were appointed to Miss Underwood, and this is a pretrial along with the failure to appear for pretrial and contempt hearing on May 28 of 25. So, actually,
And
I'm sorry.
This was Mr. Glazer's case, I think.
Yeah,
Mr.
I was
Malaro
just gonna
covering.
say, this is Mr. Glazier. So Mr. Malaro, you're covering for Haybecker.
Yes, I am, Your Honor.
So how would you like to proceed with Mr. Haybecker?
Your Honor, I'd ask to adjourn this matter. There's no notes reflecting what occurred with Mr. Glazer's actions on the file, so I cannot address what would need to be done other than ask to adjourn it.
All right, so
And
I will
just
set this, Oh, go ahead, Miss.
No,
McClure,
that's
go
okay.
ahead.
Just to make a record, I believe my memory is that we only had one pretrial with Mr. Glazier as the attorney, and from then on, we didn't get another appearance. So I don't think we've been able to make much progress on it, but I'll be in contact with Mr. Glazier. It's been the same offer that's been on the case for a long time.
All right, so I'm gonna set this over for pretrial January 21 at 8:30 in the morning. Mr. Malaro, if you can do the step in order to adjourn. Ms. McClure, can you sign your name with permission?
Yes.
Mr. Malaro, please make note if they're able to resolve this case. I will see Mr. Haybecker sooner. Mr. Haybecker, you have your hand up?
Yeah, may I even speak to my lawyer before I come into the courtroom?
Mr. Glazier, I would hope would meet with you in advance of the court date.
There is
Mr. Glazier.
no
Mr. Glazier
here today, nor was he here.
No,
2
you're
weeks
right.
ago.
Mr. Glazier is not here today to talk to you, but I'm sure he will meet with you before your next court date, okay?
Okay, I was trying to get to the point to where we could discuss, because they were supposed to, Mr. Malaro, the reason why we're here 2 weeks later is because Glacier wasn't here 2 weeks ago. So I'm in the exact same shoes as I was 2 weeks ago and nothing's getting done. I had supposed to sign a release for St. Mary's Hospital and Personalized Nursing Lighthouse.
So, Mr. Haybecker, we're here because you haven't shown up for court. That's why you've got a failure to appear for pretrial and contempt back on May 28th. If you had showed up for court, probably would have resolved this before now. But we will see you back on January 21 at 8:30 in the morning, and Mr. Malaro will make a note that Mr. Glazier needs to meet with you, or he will. Okay?
Judge, can I do a quick? Judge, can I do a quick?
Everybody stop talking over each other. Mr. Haybecker, stop talking. Stop talking. Well, you're not in a hospital because you absconded on bond. Mr. Malaro, what were you gonna say?
Judge, when I did handle this a few weeks ago, there was a discussion about releases. Could I have a breakout to find out if he's received those? And if not, I'll make sure they get done.
Okay, Mr. Haybecker, Mr. Malaro is gonna take a moment to speak with you. So I'm going to put you in that breakout room with him. There you go. Go ahead and join that breakout room.
Thank you.
All right. So. Is Matt, all right, so that one is waived. Michael, is Michael Dagger Margosian here today? Anybody know?
I don't know, but Mr.
Rhonda,
Mawad,
is Michael Dagger Margosian down the hall? Rhonda?
Yes, ma'am.
Did you see Michael Dagger Margosian down the hall?
I don't know if he's here in person. I don't know.
Okay, so you didn't see him on Zoom down the hall?
I think I know he's here on some cases.
Okay, I just didn't know if someone was covering for him today, is why I was asking.
Okay.
All right, let me see if he's
And then-
down there.
Judge, Mr. Mawad did respond back. He said he can log on, but he needs the Zoom number, and I don't have it in front of me at the moment. Do you know? Can you?
I'm gonna text it. I'm gonna chat it to you right now.
Okay. I think I know what it is from memory, but I don't want to be wrong.
Yeah, let me chat it to you real quick. All right, there it goes. All right. Search for Judge Olsaver Law Talk with Mike out of Chicago popped up. Yeah, Michael Dagger Margosian's in front of Judge Olsaver right now. So, Mr. Let's see. Becca Gerald is Michael Olsaver's. Matthew Sinclair. All right, Rhonda, I have Matthew Sinclair. All right, thank you for your patience. This is in the matter of the people of the state of Michigan versus Matthew Richard Sinclair. We have three files, 24-21920FH, 25-22245FH, 25-22246FH. I have Rhonda Underwood appearing on behalf of Mr. Sinclair. These are probation violations. Do you have a note? Mr. Coe states that Mr. Sinclair continues to be monitored by GPS tether. To date, we have no violations. He is staying out of the half-mile radius of the victim. So, Ms. Underwood, we did receive a recommendation from district court on a probation violation sentencing. Did you receive that?
Hang on, Your Honor. Thank you. I'm trying to get back into my system.
All right, Mr. Mawad, how do you not have my Zoom number? I thought I was on your favorite list.
Well, considering that I've aged another year, it's not in my memory anymore. I've lost all short-term memory and long-term memory, so I had to ask.
Okay. All right. So we'll take your case real quick. So in the matter of the people of the state of Michigan versus Benjamin Kalon Wainscott, just stand at the podium. We have three files, 24-21932FH, 24-22089FH, 23-21606FH. I have Elias Mawad appearing on behalf of Mr. Wainscott. This is the date and time for a, let me get back there. Looks like probation violation hearings. So why do I have three files? I'm only, oh, we stuck the wrong one. I misspoke. 23-21606FH is not Mr. Wainscott's file. All right, there are only the two, 24-21932 and 24-22089. So, Mr. Mawad, how would you like to proceed today with Mr. Wainscott?
Judge, he's going to be pleading on the violations. We talked yesterday.
Okay, so Mr. Wainscott, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, speak up just a little bit louder.
Okay, yes, ma'am.
Okay, so Mr. Wainscott, Mr. Mawad states that you and he had an opportunity to speak yesterday regarding the violation of probation allegations, and that it's your intention to plead guilty to these today.
Yes, ma'am.
Okay, are you satisfied with Mr. Mawad as your attorney and the advice that he's given you?
Yes.
All right, the allegations are on each of the files that you violated the terms of your probation, committing technical violations. The first allegation is that you used an illegal controlled substance, methamphetamine, testing positive on September 2nd of 25, November 18 of 25, and had failed at that time to attend treatment, and that you have failed to make regular payments towards your costs. And on file number 24-21932FH, the amount owed is $948. And on file number 24-22089FH, the amount owed is $10,898, of which $10,700 is restitution. So do you understand on file number 24-21932FH, you're on probation for larceny in a building. Your guidelines were 7 to 23. So if you plead guilty or found guilty of a violation of probation, you could be facing up to 4 years in prison. Do you understand that?
Yes, ma'am.
Okay. And on file number 24-22089, you're on probation for breaking and entering a building with intent, which is a 10-year felony. So you could be facing up to 10 years in prison. And your guidelines on that file Looks like Mr. Muad got a reduction from the guidelines on this case as part of your plea. So your guidelines on that were actually 29 to 57 months. Do you understand that?
Yes, ma'am.
So if you plead guilty or found guilty, you could be facing those prison terms. Do you understand that?
Yes.
Okay, and all right, let me get back to that for a minute. All right, and you are satisfied, obviously, with Mr. Muad as your attorney. I think I asked that.
Yes.
Okay, now, do you understand that you have a right to contest this violation of probation charge and to have a trial on it?
Yes, ma'am.
All right, do you understand that throughout the trial, you would be presumed innocent until your guilt is proven by a preponderance of the evidence?
Yes, ma'am.
Okay, I did swear you in, right?
Yes.
You did, yeah. You have a right to have all the witnesses against you appear at your trial, to have your lawyer ask those witnesses questions, or you may ask them yourself, and to have me order any witnesses you have to appear at that trial. Do you understand all of that?
Yes, ma'am.
You do not have to testify at your trial, and no one can say anything about you not testifying or hold it against you in any way. Do you understand all of that?
Yes, ma'am.
On the other hand, do you understand that you have a right to testify at your trial if you want to?
Yes, ma'am.
All right, so how do you plead to the charge that you violated the terms of your probation on each file by testing positive for methamphetamine on September 2nd and November 18 and failing to attend treatment as instructed? Guilty or not guilty?
Guilty.
Okay, and how do you plead to the charge that you have failed to make regular payments towards your fines and costs?
Guilty.
Okay, and do you understand by
I'm sorry.
go ahead.
Will I be able to talk before?
Yeah,
Not
yeah,
today.
just hold on.
Okay. I know. I
Okay,
have all this stuff.
so no, I don't, that stuff's not important right now because we're taking the plea and we're gonna set it for sentencing. And all that stuff you can talk about with the probation department and present at sentencing. I'm not taking you into custody today, all right?
Okay.
Take a breath.
No.
Okay. Do you understand by pleading guilty, you will be giving up your right to a trial as I've already explained to you?
Yes, ma'am.
Has anything been promised you by Mr. Muad or the probation department to get you to plead guilty?
No, ma'am.
If I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. Do you understand that?
Yes, ma'am.
Is it your own choice to plead guilty?
Yes, ma'am.
All right, so Mr. Wainscott, you were placed on probation, and one of the terms of your probation is that you are not to use any illegal controlled substances. Is that correct?
Yes, ma'am.
Put your papers down, just answer my questions. All right, and did you test positive for methamphetamine on September 2nd and November 18 of 25?
Yes, ma'am.
Is that because you had used methamphetamine
Yes, ma'am.
and you weren't allowed to use it?
No.
You have no legal right to use it?
No.
All right, and then you were ordered to attend treatment, is that correct?
Yes.
And you did not attend treatment?
During that.
When you were ordered to go do it, did you do it then?
Yes, but I didn't go for 6 weeks. But
Okay, so they said get in treatment and you waited 6 weeks.
no, I went immediately and I went for 2.5 months and then I.
Okay, but before that, as a term of probation, were you required to do treatment?
Yes, ma'am.
And you didn't do it
Uh,
before that?
No,
Okay, all right. Now, you were supposed to make monthly regular payments on your fines and costs, is that correct?
yes, ma'am.
And were you making full payments every month as ordered? Okay, and, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights, and he does have competent counsel. You're on probation with Chris Jones? Who are you on probation with?
No, I'm in Hillsdale at my hand.
It's with me.
Okay. Okay, it's Miss Holly here, but you're reporting in Hillsdale. Okay, all right. So, Mr. Muad, I have BOPS for December 30th, or I could give you another date if that doesn't work. December 30th at
I don't
8:15.
have a problem with December 30th. I think we need to get him, I think, Ben, you need to be honest when you talk to the probation officer who's going to do your report. Let the judge make her decision, but I think December 30th will work, Judge.
Okay, Miss Adams, could I get a notice of hearing from Mr. Wainscott for December 30 at 8:15 in the morning? I'm gonna make you come in person, okay? And then Mr. Mawad, obviously you can Zoom. So, Miss Holly, do you want him to report across the hall today to set up a time to be interviewed or do it through Hillsdale?
No, he should keep seeing Hillsdale. I'll get a hold of him.
All right, so you're gonna continue to report in Hillsdale. Continue to not use. Miss Holly is gonna call you and she's gonna do a probation violation report. It's very important your voicemail is empty and it's set up. Be truthful with her when you talk to her. She'll do a pre-sentence or a probation violation report. We'll get that to Mr. Mawad. Make sure you reach out to Mr. Mawad before that day. And we'll see you back on December 30 at 8:15. And Miss Adams, if I could get a notice of hearing from Mr. Wainscott for December 30th at 8:15 for sentencing. I don't know if she's back there.
Yes, yes.
Oh, okay. I wasn't sure. I heard doors and I wasn't sure what was going on. So you have a seat right behind you and we'll see you back on that day, all right? All
Judge,
right.
have a good Christmas. Miss Holly, have a good Christmas. And I see Mr. Malero there. Have a good Christmas. Oh, there's
You
Miss
too, Mr.
Underwood.
You too, Mr.
Everybody have a
Malad.
good Christmas. Okay.
You too, live.
Okay. Thank you.
All right. Now back to Mr. Sinclair. So Miss Underwood and Mr. Sinclair. So Miss Underwood, you did receive the probation violation recommendation for sentencing?
Yes, I have, Your Honor. I believe the recommendation, and I would ask the court to follow it, is to adjourn this matter for a couple months. And they also have no objection to the removal of the tether.
Okay, all right, so I will continue the not guilty plea and adjourn this for a couple months.
Thank you.
Mr. Sinclair, even if we remove the GPS tether, pretend you still got it on, all right?
Yes, Your Honor.
All right, Miss Adams, never mind. I think Miss Adams, we gotta amend the bond to remove the GPS tether, so I will order that. I'm gonna set this for February 25 at 8:30 in the morning.
8:30.
Remove GPS tether. You write that down. All right, and we will mail out a notice of hearing. Mr. Sinclair, it looks like you've moved, so we'll get that address from Mr. McCarron in District Court, because you're living in Toledo now, right?
Yes, that is correct, Your Honor.
All right, so we'll get that address from Mr. McCarron, but write that down. So February 28 at 8:30 in the morning.
You said the 28th?
February 28 at 8:30 in the morning. Yeah.
Okay. February 28, 8:30 a.m.
Yep. All right. Thank you. Thank you, Miss Underwood.
Your Honor, I just had one question as far as the ankle monitor. Do I just get with Darren on that about how to?
Yeah.
Okay.
Darren, do you have any direction?
Judge, did you take that requirement away?
Yes.
Okay. Judge, if I could do a breakout with him real quick, there's been a change of venue where he needs to return that device.
Okay, so Mr. Sinclair, I'm gonna open up a breakout room.
Okay, thank you.
Hold on, I'm gonna close the breakout rooms. All right.
Your Honor.
Hold on, let me do one thing at a time. Hold on. So Mr. Sinclair and Mr. Coast. Oh, yeah. Go ahead and join that breakout room. Okay, hold on, Rhonda. Let me just get there. All right, now, Miss Underwood, what were you gonna say?
I think I'm done. I don't think I have anything more with you, do I?
I guess not. You have a good weekend.
You too.
Okay, so Charles Noe, Michael Dagger Margosian.
Judge, Your Honor.
Jenkins, yep.
Your Honor, if I may.
Yeah.
With respect to Mr. Haybecker, we did have a very fruitful, lively discussion. I did do a little bit looking into the notes. There is an email or a note from end of March from the prosecutor McClure, actually, that apparently Mr. Haybecker was hospitalized and it was expected that he would have an extended stay with some serious injuries, which included some type of brain injury.
Yeah.
The last time I was here, we were supposed to send out him to sign releases to show that he was in these facilities. So it looks like what he had told me earlier does have some truthfulness to it. I'd ask the court to consider amending his bond or reinstating the bond with the GPS tether.
Can he pay for a GPS tether?
He indicated to me,
Yes.
Judge, that he or his family could. And so Judge, I'm in a kind of a difficult situation because I know nothing about these cases. And, you know, it's unfortunate Mr. Glazer's not here today, but it does appear that at one point earlier this year, he has some justification for not appearing back in May. So that would be my request on his behalf, Judge.
Miss McClure? You're muted.
Sorry about that. Excuse me. There's quite a lengthy history here, and this stems past his stay in March from when we had the failure to appear. It was actually in May and June that he was released and then failed to appear. So it was after his stay in the hospital, and I only know this because Chief Cuevas, before his passing, kept a very close eye on Mr. Haybecker because this case has been pending for so long, and we want to make sure Miss Bannon is safe because she's uncomfortable with Miss Haybecker and Mr. Haybecker, excuse me, and his behavior, especially when he's out on bond. So it's been multiple times that he's failed to appear. He has been picked up on warrants. He got an R&O in Wayne County one of the last times that he failed to appear, and then was arrested or attempted to be arrested on the warrant. So it's been a recurring problem. And yes, he has had stays where he's been hospitalized or jailed, but when he's not hospitalized or jailed, he doesn't appear. And we can't get a resolution on this case. It's probably, if I had to guess, my oldest case. So I would strongly oppose any release. Thank you.
Mr. Malaro?
Yeah, Judge, all I can say is the note that I saw back in the end of March about, it said he had 2 broken legs. So I don't think doesn't look like he could run very far. And that he had some brain damage, it said.
And Your Honor, he was jailed after that. He was jailed and released June 2nd of 2025 and then released. So from my records. So it's been since that March date.
Yeah, I'm not going to change his bond. I'll leave it as it is. We'll see you back January 21 at 8:30. Mr. Malaro, if Mr. Glazer or you resolve this case, I'll more than happily bring him back in and get a plea and get the case moving. But no, I'm not going to release him at this time. Thank you.
All right. Thank you, Judge.
Thank you. All right. Phone number. Mr. Dagger Margosian, I do have Rebecca Jarrell. So hold on. I have somebody called in using the telephone number. Can I ask your name, please?
Brian Jenkins.
Okay, thank you. All right, Mr. Malaro, you ready on Jenkins?
Yes, Judge.
Right, in the matter of, Mr. Jenkins, are you still in Virginia at the federal prison?
Yes, ma'am.
Okay, and do you have an out date on that?
August 2027, ma'am.
All right, this is in the matter of the people of the state of Michigan versus Brian Charles Jenkins, file number 2009-14318FH. Again, I'm grateful that the federal prison in Petersburg, Virginia has worked with us to allow Mr. Jenkins to appear via Zoom. Mr. Jenkins is represented by Mr. Malaro and also Mr. Glazer. This is, let me see here. Mr. Jenkins had filed the request back on September 6th of 2024, pro se, to rescind the warrant and or detainer in a motion to withdraw the guilty plea that he had entered. He pled guilty on July 29 of 2009 to home invasion, 3rd degree in front of Judge Pickard. His sentencing date was scheduled for September 11 of 2009. He was represented by Mr. Glazier. He did fail to appear on September 11 of 2009, and a bench warrant was issued. And Mr. Jenkins, when were you incarcerated in Virginia?
I believe it was, I believe it was, I got a DUI like in August of '09, and then I got other state charges while I was in jail.
So Mr. Jenkins, you've just simply been in custody since that date, correct?
Yes, ma'am.
All right, so Mr. Jenkins did in this file, as I said, plead guilty to home invasion 3rd degree, which carries a maximum penalty of up to 5 years in prison and or a $2,000 fine. I don't think we ever had an opportunity to sentence him. I guess I'm just wondering, he has been incarcerated for a very long time. Would it be possible, Ms. McClure and Mr. Malaro, if I put you in a breakout room, we could resolve this?
Yeah, sure.
So Judge, I think that reason why this wasn't resolved the last time we were here in November is because there was a motion to withdraw the plea filed in 2024.
I know.
And that was, sorry, that was outstanding.
I know. But I didn't know if something could be done and then Mr. Jenkins might be satisfied. I mean, obviously I could withdraw the plea, but then we're gonna have to start all over again on this case. And I just didn't know if maybe you guys could come up with something that
Yeah.
Mr. Jenkins would be satisfied with. So how about
Judge, I
give you-
love talking to Miss McClure, so I'm fine.
I know, she is such a joy. So I'm going to open that breakout room. And
My dog's
maybe
barking at the garbage man.
that's okay. My dog likes to snore when I'm on Zoom. All right, I'm gonna put you guys, well, he snores all the time, but I'm gonna put you guys, where are you, Phoebe? All right, Mr. Jenkins, I'm gonna let the prosecutor and Mr. Malaro talk for a moment, and then Mr. Jenkins will be back to you, okay?
Okay.
Okay. All right. Miss Iddings, I think you left something in the jury room the other day.
Yeah,
And they took it over to the clerk's
yeah, they gave it
office.
to me at the clerk's office, thank you, yeah. Is Mr. Noe here yet?
He is, but he's doing criminal matters right now.
Okay.
Mr. Noe, I do have Ms. Gerald. Actually, there you. Tell me you got bells on your shoes, Charles, with that
I might
little
as well.
Christmas suit. Do you jingle jangle? Okay. This is in the matter of Miss Gerald. Do you want to go ahead and unmute your device? Okay, there you are. This is in the matter of the people of the state of Michigan versus Rebecca Renee Gerald, file number 25-22439FH. Mr. Noe, I did pop, I'm sorry, Mr. Dagger Margosian, I'm sorry. I did pop the prosecutor into a breakout room. I will say that Miss Gerald, I have a letter from Darren Coase saying she's testing twice a week. She is completely negative, and we're going to dismiss the last contempt of court, the contempt of court. So, Mr. Dagger Margosian, how would you like to proceed today?
Well, Your Honor, I spoke with Mr. Smead yesterday, and he informed me that this case is going to be dismissed. I'm not sure that if the Nolly process has been filed yet. It sounded like it was, but I don't know if the court has that yet.
So I don't have a nollie press yet. But what I'm gonna do, so Ms. Gerald, what I'm gonna do is I'm gonna set another court date, okay? But it sounds like your case is being dismissed. So when it gets dismissed, you won't have to show up for that court date, okay?
Okay.
If it doesn't get dismissed, then you have to show up, but I have no reason to doubt Mr. Dagger Margosian. So I'm gonna set a pretrial for January 28th. Mr. Dagger Margosian, if you can do the stip in order to adjourn. And then Ms. Gerald, January 28th at 8:30 in the morning. And Mr.
Okay.
Dagger Margosian, obviously, if the nollie process filed, make sure she knows she doesn't need to appear, all right?
Will do.
Okay. What time was it? 8:45, January 28th?
January 28th at 8:30.
At 8:30, and it's via Zoom?
Yes.
Okay. Thank you.
All right. Thank you. Mr. Noe, do you have anything else, Mr. Dagger Margosian?
No, all set. Thank you, Judge.
All right, thank you. Mr. Noe, I'm sorry, now I have you. Is your client with you? I think he's ignoring me. You're all set, Ms. Gerald. You can.
Okay, thank you.
Thank you. Mr. Noe's mad at me because I asked if he had bells on his shoes. He's wearing his little Christmas suit. He has the best suits. All right. Mr. Noe, are you still with us?
Certainly am.
I'm sorry. All right, hold on one second. Is your client with you?
No, she is zooming in. She lives out of state.
Oh, okay, she's under Becky. Got it. All right. All right, this is in the matter of people of the state of Michigan versus Rebecca Williams, file number 23-21606FH. I have Charles Noe appearing on behalf of Ms. Williams. She's appearing via Zoom. Says the date and time set for pretrial. I did put my prosecutor in a breakout room, so we don't have her right yet. But Mr. Noe, how would you like to proceed today?
Your Honor, on this matter is set for pretrial. Today is the last pretrial. We have a jury trial set in February. I know there's some more discovery that the prosecutor needs to do. There's more work I'm doing on my end. So we can set this matter for another pretrial, maybe in January. I think that would be helpful.
All right, so I'll have you do the stip in order. I will set it for January 28th at 8:30 in the morning. And if you can do the stip in order to adjourn, I assure you Ms. McClure would allow you to sign her name with permission. So, Ms. McClure, this is Rebecca Williams. This matter is set for jury trial in February, and Mr. Noe would just like another pretrial in January. So I set a pretrial for January 28 at 8:30.
Okay.
Okay, and I told him you would give him permission to sign your name.
Yeah,
on the stip in order.
that's
Okay.
fine. And January what? I'm sorry.
January 28 at 8:30.
Okay. And we're considering that a final pretrial, I'm guessing?
Yes.
Okay.
Yeah, I would agree.
And then Ms. McClure on Rebecca Gerald, Mr. Dagger Margosian stated that it was his understanding a nollie pros was going to be filed in this case. And so I did dismiss. I dismissed the contempt of court. And I set a pretrial for January 28 at 8:30. And obviously, if a nollie pros is going to be filed, we won't have to come back.
Do you have a file number or spelling of that last name?
It's file number 25-22439FH.
Becky, you're free to go. You can log off. Okay.
Thank you. Bye-bye.
And Mr. Noe, you are coming over in person on your family law matter?
Yeah, I'll be over momentarily.
All right, Ms. Siddings is here
You'll hear me coming.
with bells on. Okay, thank you. Thanks for saying that, Mr. Noe. All right.
I do have a noli pros prepared by Mr. Sneed on Jarrell. I'll make sure that gets sent to the court.
Okay, perfect. So that brings us back to Mr. Jenkins. Mr. Millar, would you like a breakout room with Mr. Jenkins?
Yeah, I would, Judge.
All right, Mr. Jenkins, because you're on a phone, you'll automatically go into the breakout room.
Okay.
So let me close this room and then I will bring you back. All right.
Okay.
All right, and then we'll take a little potty break while we're waiting. All right. There you go.
Thank you, Judge.
Is Logan Milligan a witness?
Yes.
Okay.
I'm in my office, calling him right now to let him know.
All right. So, Mr. Jones, we're gonna step off the bench for just a minute.
Am I done then? That what you're dealing with in Virginia wouldn't
That is a case. Mr. Hertung's here to mock me for my child being gone for Christmas, but no, that guy was never sentenced.
Okay.
So you might want to stay on it. It's a 2009 case. I think Mr. Hertung is a prosecutor in it.
Okay.
Brian Jenkins. He was 2009. He didn't show up for sentencing because he got put in federal prison.
That's a harsh remedy.
Yeah. Were you looking for me?
No, I was actually looking for Sam. I see
He's already left.
Yep.
No, actually, he's in a breakout room with Mr. Jenkins,
Okay.
who's in prison in Virginia. Do you want into the back room?
Yeah, and then when Charles comes back, they could be ready for a few minutes.
Hold on a second, Mr. Hertung.
Make sure you show the judge as well.
That's funny. Oh my goodness.
He must have been going through old photos.
Huh?
He must have been going through old stuff.
Hi there. Thank you, sir.
He'll be here. You'll hear him, Evan. There he is. I'm sorry. Yeah, we were just. Great, you guys.
Please rise, start course now session. Okay, be seated.
All right, Mr. Malaro, are you back, Mindy?
Yes, Judge, I'm back. Thank you.
Okay. All right, Mr. Malaro, let me bring this gentleman back. All right, Mr. Jenkins.
Yes, ma'am.
All right, so Mr. Malaro, you've had a chance to speak with Mr. Jenkins. Are we proceeding on the motion to withdraw?
Your Honor, I do not have a copy of the motion to withdraw, but I would ask the court, I don't know if there's been a PSI prepared. If not, if the court, I mean, we're willing to waive that and proceed to sentencing. All this happened before he went to prison and federal system, so I can't imagine it would all run concurrent. I looked at the guidelines for a home invasion third. Even if you went to the entire max, he would have maxed out by now. So I think if without committing the court to anything, if we're looking at time served, Mr. Jenkins would be willing to withdraw his motion and proceed to sentencing today. But I'm not certain of the court's position.
So Ms. McClure, obviously the offense date's 2009. He's been in prison since 2009, so that's 16 years around. Do you have any objection to waiving a PSI?
I do not, Your Honor. And I was just going to say that just for the record, that motion to withdraw, from my look back on the ROA, it looks like he did file that pro se without an attorney, and our office was never properly served of that.
Yeah.
So as long as that would get withdrawn, I have no objection if the court wants to proceed to sentencing. I think under the Crime Victims' Rights Act, I'm not allowed to waive it, but if the court's able to do that, I'm fine with that.
So wasn't this Judy? Okay. All right. And so Mr. Jenkins, obviously we've been having a lot of conversations here because you've been incarcerated for like 16 years now. Did you have a chance to speak with Mr. Malaro?
Yes, ma'am.
Okay, so we have two choices today. I can provide copies of your motion to withdraw to both the prosecutor and the public defender, and we can proceed on that. Or, as Mr. Malaro stated, what did you say the guidelines were, Mr. Malaro?
Judge, I mean, home invasion third's a 5-year, his max would be 24 to 76 months on the guidelines, and that'd be the worst, which far exceeds 16 years he's been in prison.
And Mr. Jones, obviously you're here from the Department of Corrections. This case, he's been in federal prison since 2009. That's why he didn't show up or get his PSI done. I know that you can't waive a PSI, but the court has discretion. Is that correct, Mr. Jones?
That's correct, Judge.
Okay. All right.
If you guys can tell me if you have a date, I can figure out the calculations of time of whatever you guys need. I just don't know what day we were going to start this from.
Mr. Jenkins, do you remember the date you went to jail?
September 15th, 2010.
September 15th of 2010?
Yes.
That's the felony, or is that the one you went to federal prison on, or is that the day you went on the OWI out of Virginia?
Yeah, that was the OWI. I did 2 years in state, and the state paroled me to my federal sentence. My federal sentence started November 2nd of 2012.
All right, so we're going to use the date of September 15, Mr. Jones, of 2010.
Yes. Judge, if it helps, and maybe Mr. Jenkins can correct me, I have in my records that he was in a county jail, Pleasant County, West Virginia, in January 7th, 2009. So I believe, so I believe he was incarcerated from that date.
All right, we're going to go with January 7th of 2009.
And the only reason that's important, in my opinion, is because his sentencing here was September 2009. So that does, in fact, predate the failure to appear.
Okay. All right, so Mr. Jenkins, so you have two choices. We can proceed on your motion to withdraw, or you can waive a pre-sentence report and move to sentencing today.
That sounds good, Your Honor.
Okay,
We'll
because I
waive
think
it.
at the end of the day, you just want this addressed so you can get paroled out on federal, right?
Yes, Your Honor.
Okay, so Mr. Malaro, you have no objection to waiving the pre-sentence report?
Yeah, Judge, at this time, we would withdraw his motion to withdraw the plea. And we also would ask the court to waive the pre-sentence report.
Okay, and Ms. McClure, have no position or objection to that?
No objection.
All right.
What, Mr. Miller, what did you say guidelines were? I just wanted to note that.
So I quickly looked at it's an E-grid home invasion third. If he was at the far end of the PRVs and OVs, and he was on a habitual fourth, okay. I had him at 24 to 76.
Okay.
I mean, that's the, the ultimate worst, and that's typically,
That's fine. I just wanted to make note of it for our file.
Okay.
if he's in a, regular, it'd be 24 to 38.
Okay. All right. Okay, so, Ms. McClure, before the court moves to sentencing, is there anything you'd like to say on behalf of the people?
Just because I know the court doesn't have a lot of information about this case, I just did a brief review of it and would indicate that this was it stemmed from a previous domestic violence incident. There was a violation of the domestic violence bond conditions at the time of this home invasion. And he did break into his ex-girlfriend's, I believe it was a trailer or a home, wherever she resided, with a knife, and then fled the area. So that's the basis of these charges, and I just wanted the court to be aware.
Okay. So since I went to law school, my math skills, not the greatest. The maximum penalty on this offense is 60 months. If I times that by 365, that comes, well, hold on, 60 months. I would just give him credit for the 60 months. Do I have to add? Okay. All right. So Mr. Malaro, anything you want to say on behalf of Mr. Jenkins?
I think everything that can be said has been said, Judge.
All right. All right. Mr. Jenkins, is there anything you want to say on your own behalf?
No, sir. I'm just want to apologize to all the hoops we had to jump through to come to this conclusion and all the delays.
Well, Mr. Jenkins, I will commend you for reaching out and trying to address that. So in this case, parties have all knowingly waived a pre-sentence report. This file is over 15 years old. We do not, and even though this crime does involve a victim, he has already served the entire sentence, so I am comfortable proceeding to sentencing today. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing, the criteria and reasons for the sentence of the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and protection of society. Sentence of the court that you will serve 24 to 60 months with the Michigan Department of Corrections, but I'm going to give you credit for the full 5 years that you've served, and it will run concurrent with the sentence he is currently serving. So, sir, your sentence is complete for purposes of the state of Michigan. There is a $68 state cost and a $130 crime victim fee. I don't have information on restitution, Ms. McClure.
I don't think there would be any, as far as I can tell.
So no restitution. So, Mr. Jenkins, I've given you full credit because you basically maxed out the sentence, so there wouldn't be parole or anything through the state of Michigan. So 24 to 60 months, credit for the full 60 months served. The start date will be January 7th of 2009, and that will be concurrent with the sentence that you served at that time. So you receive full credit. You do have the right to appeal the sentence. We have the address for you, P.O. Box 1000, Petersburg, Virginia, at the Federal Correction Complex there. We're going to do a couple things. One, we're going to mail to you the paperwork showing that you've been sentenced and given credit for time served. Two,
Okay.
we're going to mail your notice of right to appellate review to you. There's going to be 3 copies, 2 for your records. 1, there'll be a self-addressed stamped envelope for you to return to me. So you'll initial and date it. You'll return it back to us so that we know you received your appellate rights. If you wish to appeal your sentence, you would fill out the information on the paperwork and mail it back within 42 days. Obviously, you're in Virginia. The mail is a little wonky right now. So if it gets here a little late, we'll still look at it. Is there anything else, Ms. McClure or Mr. Malaro?
No, Your Honor.
No, Your Honor, thank you.
All right, Mr. Jones, is there anything else you need from me?
No, Judge.
All right, so Mr. Jenkins, I wish you the very best of luck. Thank you.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
And that does conclude our criminal docket for the day.
Have a good
Thank
day,
you.
Judge.